Did you receive something in the mail that directed you to be here today?
No, my probation officer told me, she gave me the Zoom ID, and she told me this was something about me paying restitution. She never said I was violated.
Give me a moment.
Ms. Davis,
Yes, Miss Walsh.
does your phone number begin with 810?
I just got the paper. My probation officer did not tell me that I was being violated. What am I being violated?
Okay, Ms. Davis, I need you to just slow down. Did you get
I'm
that
sorry.
document?
I thought I was just in a meeting with Miss Walsh. I apologize.
Did you get that document or did you not get that document?
Yes, I'm looking at it now.
All right. So the summons and request for probation violation alleges that you violated the terms of your probation by failing to pay your restitution and failing to pay your court costs. Do you understand that?
I've been paying my probation.
Ms. Davis, I have to ask you some questions to make sure that you understand your rights. So I don't want to get into the content of what you've paid and what you've not paid right now. I would like you to listen to my question and answer it directly, please. Do you understand that that is the allegation against you?
Yes.
You had previously pled guilty in this case to failure to return rented property of $1,000 or more, but less than $20,000. And the maximum penalty for that charge is up to 5 years in prison or $10,000 in fines or 3 times the amount of what was failed to be returned. You do have the right to be represented by an attorney at this hearing and at any other hearings that we have regarding this matter. If you can't afford your own attorney, you can tell me that and I will appoint one for you at public expense. Do you understand that?
Yes.
Would you like to be represented by an attorney?
Yes.
Do you have the ability to pay for your own attorney?
No.
Okay, I'm going to appoint the public defender's office to represent you. And we will send them your paperwork right now. And, oh, I'm sorry, Ms. Underwood, you already have the paperwork for Ms. Davis?
One moment, Your Honor.
All right. We should have sent it to you yesterday.
Thank you.
Testing facility, they're everywhere. All right.
Okay. Driving groups. I'm not seeing anything. I am not.
All right, we will send it. We'll send it to you again.
Hi, it's Kelly and Judge Wilson.
Thank you.
Thank you.
Oh, I found it.
All right, I will put you in a breakout session with Ms. Davis
Thank
right
you.
now. Okay, Mr. Murphy, we have Mr. Bortner here from Department of Corrections. Do you need a breakout session with him?
Please, Your Honor.
All right, Mr. Bortner, I'm going to place you in a breakout session with your attorney if you give me just a moment.
All right, sir.
Okay, Mr. Daly, we have Mr. Berger Ellis is here from the jail now.
Yes, Your Honor.
Are you ready to call his case?
Yes, Your Honor.
Okay. You are on the record in file 19-19274-FH and 24-21706-FH. People versus Michael Henry Berger Ellis. We are here today for an arraignment in the 24 case in a probation violation in the 19 case. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayonetto.
Morning, Your Honor. Alex Bayonetto for the people.
James Daly on behalf of the defendant.
All right, and we have Mr. Berger Ellis here by Zoom at the jail, although he's pointing to his ear as though he can't hear us. Mr. Brugger Ellis, are you able to hear me?
All right, so I need to turn up or something. 1 second.
All right. Right, is it any better now, Mr. Brugger Ellis?
A little better. He's trying to fix it. Maybe that, yeah. All right,
All right, are you able to hear me now, Mr. Brugger Ellis?
sorry.
Can you hear us, sir?
Yes, sir.
Okay, so Mr. Daly, does Mr. Brugger Ellis wish to have the information read?
No, Your Honor, we would waive the reading of the information. We would ask to have the 24 matter set for trial. And the DOP from 1919. I'd like to set that at the same time as the trial if I can, Your Honor.
Okay, so we'll enter a not guilty plea for Mr. Brugger Ellis in the 24 case. Mr. Bayonet, was there anything we need to address from the people's side?
Your Honor, I'm not familiar with this case. This is Ms. Arnold's case. She is in trial this week. I don't know how long a trial would even take. I think perhaps a pretrial first would be would better serve with judicial resources. So
Judge, that's what I was gonna jump in and say. Miss Arnold did leave me a message on this case and on her other cases, not to set any trials for her today because she wants to weigh in, given her schedule being as busy as it is lately. She wants to weigh in on any trial dates that might get set. Just because this is an arraignment, I would just ask for a pretrial before we proceed.
All right, is Ms. Arnold going to be available next week on the 14th if we set it for a pretrial on the 14th?
she should be, Your Honor, yes.
All right, so I will enter a not guilty plea for Mr. Brugger Ellis. We'll set it for a pretrial on February 14th at 8:15 a.m. With the expectation that we will be able to set it for a trial at that time.
Thank you, Your Honor.
Thank you, Your Honor.
And we'll set the probation violation for the same date.
Thank you.
Thank you then, Mr. Brugger Ellis. You can let the officer that's with you know that you are done with work for today.
Okay, thank you.
All right, we have Ms. Underwood and Ms. Davis back from the breakout session. Ms. Underwood, you know how Ms. Davis would like to proceed today.
Your Honor, I would ask the court to enter a not guilty plea on Ms. Davis's behalf. Ms. Davis has an interview scheduled at Wendy's for a job, Your Honor. She's also able to make a $300 payment today. We would ask that this matter be set out for a pretrial in perhaps 2 weeks, Your Honor, by which hopefully Ms. Davis will have regular employment and we can get some more movement on payment, Your Honor.
All right, I will enter a not guilty plea for Ms. Davis. And we can set this for a pretrial on February 21st at 8:15 a.m. So Ms. Davis, you'll need to log back in on February 21st at 8:15 a.m. You'll use all the same Zoom information that you used today.
Okay.
Thank you, Your Honor.
So you're all set, Ms. Davis. You can log out.
Thank you.
Okay. Do you want to hold Mr. Ms. Underwood, we have Ms. Petty here in the courtroom. Do you need to speak with her?
Yes, Your Honor. I'll be right.
All right. We can set up the iPad if you would rather do it in a breakout session.
No, it's easier for me probably just to run upstairs, Your Honor.
Okay. Okay, Mr. Murphy, are you ready to proceed with Mr. Bordner?
Yes, Your Honor.
Okay. We are on the record in files 23-21595-FH and 23-21596-FH, People versus Chad Michael Bordner. We are here today for pretrial hearings in both of those cases, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
DB McClure on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Bordner.
And Mr. Murphy, where do we stand with Mr. Bordner's cases today?
Your Honor, I was going to ask the court if we could schedule just one more pretrial. I need to just talk to Mr. Bordner and Ms. McClure further about the case. I believe there's a misdemeanor pretrial down in district court on the 15th. So obviously he'll be present for that via Zoom if I can't talk to him before then. I'm hoping to have a discussion and get the case resolved either by that pretrial with a plea, or we'll set it for trial at that time. But I'm just asking for one more pretrial.
All right, so the case is at 98 days right now since the bind over. I'm not really comfortable with additional pretrials, so I think it's more appropriate to set this for trial at this time so we have a date by which we're going to move forward one way or another. And obviously, if it gets resolved in the meantime, we'll be happy to accommodate the parties if they need a hearing to enter a plea or do whatever it is they need to do. But at this point, I think we need some hard deadlines in this case.
Your Honor, well, could I have one more breakout with Mr. Bordner then, please, if the court could accommodate this morning?
All right, give me 1 second.
Thank you.
All right, gentlemen at the jail, you are Mr. Gwynn.
Yes.
Mr. Dagger-Margosi, do you need a breakout session with Mr. Gwynn?
Yes, please.
Okay, Mr. Goldstein, I think we have Mr. Lyles here. Do you need a breakout session with him, or are you ready to go on the record?
We're ready to go, Your Honor.
Okay, we are on the record in files 22-20789-FH and 23-21433-FH. People versus Jacoby Wayne Lyles. We are here today for a pretrial in the 23 case, a probation violation in the 22 case. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
David I. Goldstein appearing on behalf of the defendant.
All right, and we do have Mr. Lyles here by video conference as well. Mr. Goldstein, where do we stand with Mr. Lyles' case?
Your Honor, there has been an offer made in this case. My client and I have discussed it. He is not prepared at this point to accept or reject that offer. We would like some opportunity to continue discussing with Mr. Bayonetto. But given the age of the case, my suggestion would be to set it for a jury trial. It's going to be, I'm assuming, some time before that trial comes. And Mr. Bayonetto and I can continue discussing the matter in the meantime.
Mr. Bayonetto, anything to address from the people's side?
Your Honor, the only thing, Your Honor, I think this will just be a one-day jury trial.
Okay.
Should be only be
I
a
would
few witnesses.
agree, Your Honor.
Okay.
Sorry, Alex.
Okay, so Ms. Clark, we'll need a one-day jury trial date, please.
Friday, April 5th at 9 a.m.
Just a second, I got to open my calendar. Hang on. April 5, you said?
Yes.
Yeah, I could probably do that. Well, Judge, I would say yes. The only problem is I started jury trial on Wednesday in Hillsdale County, and that one may not be done by Friday. That's my only concern.
Okay, Ms. Clark, then let's look for the next available date we would have.
Friday, April 19th at 9 a.m.
Yeah, that would work. Oh, wait a minute. No, I'm sorry. I'm going to be out of town that day. I could do the next week.
Ms. Clark, what's our next available date after the 19th?
Friday, April 26th.
Yeah, that would work.
That would work for the people as well, Your Honor.
Okay, thank you. So Friday, April 26th at 9 a.m. Let's do a final pretrial on Wednesday, April 17th at 8:15.
Your Honor, I would like to address the court on an issue of bond when the court's ready.
All right, before you do that, Mr. Goldstein, I know you've appeared, but we don't have appearances for you in the written form in the file, and we need you to do that.
On either case, Your Honor, because we show that we sent on both, but we'll send them again. I've got copies in my file, but we'll send them again.
Okay. All right, so what is the bond issue that you wanted to address?
Your Honor, I've only been in this case since December, but my understanding is this case has been pending for quite some time. Mr. Lyles has been on a GPS tether, and I would assume, since I've not seen anything in the file but any violations, that he has complied. He's asking the court if he could drop that requirement could be dropped for several reasons, one of which obviously is the financial burden. Mr. Lyles does support children, and with the added expense of the tether, it's making it very difficult for him. He also is engaged in a number of activities, particularly of a sports nature, where he both plays and coaches, for example, football, and wearing a tether in that situation is very, very difficult. So since he has complied, there doesn't seem to be any issue with that if the court would consider dropping the requirement of the GPS tether. I would also say, Your Honor, very briefly, he has appeared, at least since I've been in the case, he has appeared every time he's been required to appear. So risk of flight is not an issue here.
Mr. Bayonetto, any position people want to take?
Your Honor, I do understand Mr. Lyle's position. However, fact of the matter is he has a fairly extensive criminal history of this type of behavior that stems down to when he was in Texas. He was on probation already for resisting and opposing an officer. And while he's on probation, then he is alleged to have committed this crime. I believe there is a high likelihood of conviction should this matter proceed to trial. And so I think the bond is appropriate as it is. I do understand the financial burden, but Mr. Lyles, again, has an extensive history of this type of behavior.
Your Honor, if I could just very briefly say, I understand Mr. Bayonetto's position. However, the GPS really goes more to the issue of risk of flight than it does to anything else. And I don't think there's any history, at least not since I've known the case, of Mr. Lyles not appearing.
All right, so the bond condition is that he was released on a PR bond with a GPS tether and a scram unit, and that he be on house arrest from 9 p.m. to 5:30 a.m. That was done because alcohol is, it appears to me, the issue that is causing the other issues. He was arrested in the current case for a DUI and resisting and obstructing. The prior case, the 22 case, involved a domestic assault during which Mr. Lyles was intoxicated at the time of that. And so the GPS was put in place to make sure that Mr. Lyles is not drinking while he's out on bond. And I believe that that is still necessary and appropriate at this point. So I'm going to deny that request.
Thank you, Your Honor.
All right, so we are all set then. The court will issue a scheduling order with the trial date and pretrial date.
Can I please say something? I've been on this for 9 months. I know that. I'm paying weekly visitation so I can see my son. I'm trying to prove to everybody without this alcohol tether that I'm done drinking. Like, it's taken so much from me. I lost my ex-old lady and my kids because of it. I'm done. I'm trying. I'm joined sports to try to get better in my life.
All right. Record should reflect that I've muted Mr. Lyles. He's continuing to talk and being disruptive to the proceedings. Mr. Goldstein has made his motion. He's made his argument. I've made my decision. That is the end of it. So, again, the court will issue a scheduling order and send that to the attorneys. So thank you for your time, Mr. Goldstein, Mr. Lyles. You can go ahead and log out.
I thank you, Your Honor. I do have one more matter, but I have to take care of something here. I'll log back in a little while. I have Jason Crone. morning also.
Okay, thank you. Okay, Mr. Dagger Margosian, are you ready to proceed with Mr. Gwynn?
Yes, Your Honor.
All right, we are on record in file 23-21650-FH, People versus Justin Allen Gwynn. We are here today for pretrial conferences in both of those cases. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Gwynn.
Okay, and Mr. Dagger Margosian, where do we stand with Mr. Gwynn's cases today?
Your Honor, we are in a position to enter a plea on both of these matters. Mr. Gwynn has been screened and approved for drug court. And so in light of that, we're ready to enter a plea on 650. It will be a plea to meth possession and dismiss the R&O. On 21666, it will be plea guilty to larceny from a motor vehicle.
Okay, Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is.
Okay. Mr. Gwynn, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Justin Allen Gwynn?
Yes, sir.
Mr. Gwynn, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 23-21650-FH to possession of methamphetamine?
Yes, it is.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine?
Yes, I do.
Is it your intention in file 23-21666-FH to plead guilty to larceny from a motor vehicle?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $10,000 fine?
Yes, sir.
Are you satisfied with Mr. Dagger Margosian and the advice that he's given?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as has been discussed on the record here this morning. Is that correct, Ms. McClure?
That's correct.
Mr. Dagger Margosian?
Correct, Your Honor.
Is that also your understanding, Mr. Gwynn?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at the trial if you wanted to testify. You understand, Mr. Gwynn, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to the pleas would be by application for leave to appeal and not by right.
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights that I've explained to you?
No, Your Honor.
And do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead in file 23-21650-FH to the charge that on or about December 4, 2023 in the city of Adrian, county of Lenawee, that you did commit the offense of possession of methamphetamine?
Guilty.
And in file 23-21666-FH, how do you wish to plead to the charge that on or about November 5, 2023 in the city of Adrian, county of Lenawee, that you did commit the offense of larceny from a motor vehicle?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your pleas, you're giving up any and all claims that your pleas are given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes, Your Honor.
The prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Gwynn to plead guilty?
No, Your Honor.
No.
Mr. Gwynn, other than as we've discussed on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty this morning?
Yes, Your Honor.
Mr. Dagner-Margosi, do you want to establish a factual basis?
That's fine, Your Honor. Mr. Gwynn, on December 4th of 2023, were you in the city of Adrian, county of Lenawee, state of Michigan?
Yes.
All right. And at that time, did you possess methamphetamine?
Yes.
And you didn't have a legal right to possess that?
No.
All right. You knew it was methamphetamine?
Yes.
Okay. I think I'm satisfied on that case.
All right, Ms. McClure.
Yep.
Okay. All right, go ahead, Mr. Dagner-Margosi.
And then, Mr. Gwynn, on November 5th of 2023, were you in a Meyer parking lot, which was in the city of Adrian, county of Lenawee, state of Michigan?
Yes.
Did you go into a vehicle that did not belong to you?
Yes, I did.
Did you take a backpack that had a computer in it?
I took a backpack.
All right. And that belonged to other than yourself, obviously?
Yes.
Okay. Satisfied, Judge.
Did the backpack have a computer in it?
No.
Did it have any electronic in it?
No.
Then the elements haven't been met, Judge. It has to be some sort of electronic device from a motor vehicle.
I'm not sure that's true, Judge. It's a larceny from a motor vehicle. He took an item, a backpack from a motor vehicle.
I understand, but under the statute for larceny from a motor vehicle, it has to be certain things.
There was none.
It has to be either a wheel, a tire, airbag, catalytic converter, radio, stereo, clock, telephone, computer, or other electronic device.
What about a mouse?
Sorry?
Mouse. It had a mouse in it. It didn't have a computer, though. There was no computer. There was a battery-powered mouse that has the ones you put the USB into.
I guess I'll leave it in the discretion of the court, but if there's not going to be any objection that falls under the statute.
Fine with defense.
I'm sorry, Mr. Dagner-Margosi, your audio is unclear.
I'm sorry. The mouse, the electronic mouse, I would think qualifies.
All right, I believe that the mouse would qualify as an electronic device under the statute, and so I will accept that as establishing factual basis for count one, larceny from a motor vehicle. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Yes.
All right, I will accept the pleas then. They have been given understandably, voluntarily, and accurately. Mr. Gwynn has had full knowledge of his rights. He's had competent counsel. Court's not made any agreement other than as we discussed on the record this morning about a possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation, and we can set sentencing for March 14th at 8:15 a.m. Mr. Gwynn, someone from the probation office is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, sir.
All right, bond will be continued, and we'll see you back for sentencing on March 14th. You can let the officer that's with you know that you are done with court for today, Mr. Gwynn.
All right, thank you.
Mr. Murphy, are you ready to proceed now with Mr. Bordner?
Yes, Your Honor.
Before we do that, Mr. Dagger Margosian, I think we have Mr. Bryan here. Do you need a breakout session with him?
Yes, please, Your Honor.
Okay. Just a second, we'll set that up and then we'll get to Mr. Bordner's case. All right, I have someone logged into the Zoom session as Tim Bryan. I need you to unmute that device, please.
Go ahead, Kyle. Just tell him you unmuted it.
Okay, sir, are you Kyle Bryan?
Yes, sir.
All right, Mr. Bryan, I'm going to put you in a breakout session with Mr. Dagger Margosian if you give me just a moment.
Okay.
Okay, we're back on the record in People versus Chad Michael Bordner, files 23-21595 and 23-21596. Mr. Murphy, where do we stand at this point?
Your Honor, at this time, we'd ask the court just to go ahead and schedule just a one-day jury trial on this matter, whatever fits the court's schedule best, and then a pre-trial or a final pre-trial on the matter. And if I come to a resolution prior to that final pre-trial, I may contact the court to see if we can get in a non-busy day.
All right.
Judge, I would ask for a stipulation from defense that these be consolidated. If not, I'll file a motion, but regardless, can you set them together for trial?
We'd stipulate that they be combined together, Your Honor.
Thank you.
So we have a stipulation to consolidate the two files. Is that still a one-day trial, do you think then?
Probably a 2-day.
Yep, probably a 2-day if it goes.
Okay. So Ms. Clark will need a 2-day jury trial date, please.
Okay, how about May 2nd at 9 a.m. and May 3rd at 9 a.m.?
That works for the defense, Your Honor.
That works for the people.
Okay, so May 2nd and 3rd at 9 a.m. for the trial. And let's do a final pre-trial on April 24th. At 8:15 a.m.
And Mr. Murphy, do you want Mr. Bordner in person for those, or do you just want to Zoom writ?
In person for the trial, but Zoom writ for the pretrial is fine.
Okay, court will issue a scheduling order. Is there anything we need to address, anything else we need to address with this case today?
Nothing further from the defense, Your Honor. Thank you.
No, thank you.
Okay, Mr. Bordner, then you can let the officer with you know that you are done with court for today.
All right, thank you, Your Honor.
Thank you, Mr. Bordner. You have a good day. Talk with you again
You
soon.
too, Mr. Murphy. All right, thank you.
Okay, Ms. Underwood, are you ready to proceed with Ms. Petty?
I am, Your Honor. Thank you.
Petty, you want to come and sit at the table right here, please? This is file 23-21571-FH, People versus Monica Lee Petty. We are here today for a pretrial, I'm sorry, yeah. Case, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Rhonda Underwood on behalf of Ms. Petty, Your Honor.
All right, and Ms. Underwood, where do we stand with Ms. Petty's case today?
Your Honor, I believe this matter is going to be resolved. Ms. Petty is endeavoring to come up with money to allow for that resolution, Your Honor. We would ask for a 60-day adjournment to prepare this case for that resolution, Your Honor.
Ms. McClure, is there anything we need to address from the people's side today?
Just that at this time, the offer would be to, hold on, I'm sorry. The offer would be to plead as charged with no subs, and she would have to have restitution in full in order for her to continue in diversion. This is a case where she had started in diversion a while ago and then never completed it. So I guess I'm good with one more adjournment, but this has been hanging out there a while for her to get money, so to speak.
Yep. She's endeavoring to do that, Ms. McClure. And I understand the impatience. I do.
I don't have any notes that she's met with Bob Wendt either, though, so that doesn't necessarily help her case.
All right, so I will do this. This case is 120 days since bind over at this point. And so I will do one more adjournment, but if we're in the same spot next time, then I'm going to have to.
Thank you, Your Honor.
So I will set it for a pretrial on April 10th.
April
At
10th.
8:15.
And I will do the stipend adjournment with Ms. McClure's permission.
No objection.
Okay, so Ms. Petty, April 10th at 8:15 is your next date.
Okay, thank you.
Okay.
Thank you, Anna.
Hold on.
Mr. Bennett, I have not seen Mr. Jones. Do you know anything about where he might be?
Your Honor, he says that he's logged on.
Okay, I do. I did just get a device a couple minutes ago that's just labeled iPhone, so we can see if this is him. All right, so his
kind of dark, but I believe that's him. There's not a lot of light.
Right. Sir, are you
Okay.
Mr. Jones?
Yes, I'm about to get into a lighted more area.
Okay. Mr. Bennett, do you need a breakout session with Mr. Jones?
I do not.
All right, we are on the record in file 23-21615-FH and 23-21616-FH. People versus Maurice Leroy Jones, here for pretrials in both of those cases. Both of those cases also have a contempt for violating bond conditions. We're proceeding today by video conference, and let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, Math the People, filling in for prosecutor of record Allison Arnold.
Morning, Your Honor. For the record, my name is Jeffrey Bennett. I'm appearing with and on behalf of Mr. Jones, both of us by Zoom from different locations.
All right, Mr. Bennett, where do we stand with Mr. Jones' cases today?
Yes, Your Honor. At the last pretrial, we were awaiting the preliminary examination transcript. I do have that now. Ms. Arnold was going to get me a plea offer that would be a global resolution of all of these cases. However, she's had to step in for Ms. Wise apparently. So she's actually, I don't know if she contacted Ms. McClure, but she said that we should probably just put this out so we can try to resolve all these issues.
That was the message I got as well.
All right, I will adjourn this. I would note the case is 81 days old, so this is likely to be the last adjournment at this time. I understand the need to negotiate and try to reach a deal, but we also need to move these cases more efficiently. So I would expect to set this for trial at the next pretrial hearing, which I will set for March 6th at 8:15.
Your Honor, I believe that there's an additional contempt that was just filed.
So we do have a letter in the file from Mr. Coast indicating, along with a motion, affidavit, and bench warrant for a new contempt alleging a positive drug test.
Your Honor, I would waive the formal reading of the allegation and ask that the court enter a not guilty plea on behalf of Mr. Jones, and then move this along with the other stuff.
All right. Well, I guess I haven't even signed the warrant at this point, and
okay.
So I'm going to sign that warrant now, and I think that at this point, Mr. Jones needs to turn himself in on that warrant. This is the second positive cocaine test that we've had in about a month's time, and I am no longer comfortable with current bond conditions.
Your Honor, what I would say is that our office has been in very close contact with Mr. Jones. He denies that he's using cocaine. He understands that there are these positive tests, but he doesn't understand how that's possible based upon the fact that he's not using cocaine.
Judge, we had two positives and at Mr. Jones's request, sent him into the lab, and both lab results confirmed that it was cocaine.
All right, I appreciate that Mr. Jones denies and will enter a not guilty plea when he's brought forth on the warrant. But as I indicated, this is second positive cocaine test in short order. They've both been lab confirmed. And at this point, I need to act. So that's what I'm doing. I've signed the warrants. Mr. Jones, you need to turn yourself in on those warrants.
And then he'll be arraigned on him, Your Honor.
Yes.
I would ask that I be notified of the arraignment so that I can be present.
We will get in touch with you as soon as we can, as soon as that happens. So Mr. Jones has his hand raised. Mr. Bennett, do you want a breakout session with him so you can hear what he wants to say?
Yes.
Give me one moment.
Right.
Mr. Sala, I do not have, I think you have Mr. Highland. I don't have him logged in. Oh, he's with you. Okay.
I got it on my pictures. Okay.
I have had discussions with Mr. McCready. He's asking for adjournment, as am I. There's some more.
Okay. All right. Let me call the case real quick, and then we can do that. So it's file 23-21536-FH People versus Matthew Lee Highland. We are here today for a pretrial conference. In this case, we're proceeding by video conference. First, let me have the attorneys place their appearances on the record, beginning with Mr. McCready. Mr. McCready, if you said anything, I did not hear you.
I think he's frozen.
Appears to be frozen.
Good picture.
And now he's gone. See if he comes back to us. Okay, in the meantime, Mr. Dagger, oh, hang on, we've got Mr. McCready again. All right, Mr. McCready, are you there?
Yeah, my computer froze. I'm not sure what happened, but
okay. All right, you want to go place your appearance on the record, please?
Dave McCready for the people.
Stan Sal on behalf of Mr. Highland.
All right, and Mr. Sal, I believe you were indicating before we called the case that you were requesting an adjournment.
Yes, I have had, I've been chatting with Mr. McCready while we've been waiting, and we both, he has some more potential evidence that he's going to forward to me, and I'm still waiting for the transcript. So we'd ask for the case to be adjourned at this point.
And I have no objection to that.
We don't appear to have the transcript yet, so. Go with March 13th at 8:15, if that works.
It won't work for me, Your Honor, but I could have someone stand in for me at that point. I think.
It'll work for me via Zoom. Yeah, it'll just be Zoom pretrial. That's fine.
So March 13th at 8:15 a.m. Mr. Sala, would you prepare that stipulation in order?
Yes, sure.
All right. I also believe we don't have a TCN number, meaning we need fingerprints for Mr. Highland. So I'm going to do an order for fingerprints.
He has indicated to me he did get his fingerprints taken at the jail, but we can send him there again.
All right. We'll try to follow up on that and see if they have what we need for him. Otherwise, we're going to have him do it again.
I understand. Thank you.
Okay. Anything else we need to address in this case today, Mr. Sala or Mr. McCready?
No, Your
Honor.
All right. Thank you then. Mr. Sala, you can go ahead and log out.
Thank you.
Your Honor, I'm not sure that Mr. Jones knows how to get out of the breakout room.
I just
there
moved
he is.
him back. So we have Mr. Jones back now. So Mr. Bennett, is there anything further we need to address at this point?
Your Honor, I think that it's most appropriate that I address Mr. Jones's issue at the arraignment. There are a couple of things I want to check on. So at this point, I've directed Mr. Jones to turn himself in today, and then I'll appear at the arraignment and make a bond argument.
Okay, we will take it up at that point then.
Thank you, Your Honor.
Thank you. And Mr. Jones, you can go ahead and log out.
Okay.
Sir Dagger Margosian, are you ready to proceed with Mr. Bryan?
Your Honor, Mr. Bayonetto and I are just talking about one specific point. If we could just pass the matter for a moment.
Sure. Yes, sir. Good morning, sir. Are you Mr. Folds?
Yes, sir.
Okay, Mr. Folds, your attorney is not logged in to my courtroom right now. So I'm gonna just put you back in the waiting room. As soon as she does get logged in here, I'll bring you back in and we'll get to your case.
Okay, sir. Thank you.
Thank you. Okay, Ms. Hennigan, are you ready to proceed with Mr. Lester?
I am, Your Honor.
Okay. We are on record in file 23-21516-FH, People versus Donald Raymond Lamont Lester. We are here today for a pretrial hearing in this case, and we're proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
E.B. McClure on behalf of the people.
Good morning, Your Honor. Tamiris Hennigan on behalf of Donald Lamont Lester, who also goes by the name Damiano Fain.
Sorry, what was that second name?
Damiano, D-O-M-I-A-N-O. Last name Fain, F as in Frank, A-I-N.
All right. Okay, so where do we stand with this case today, Ms. Hennigan?
Your Honor, I did have opportunity to meet with my client just this past week. This case has been reassigned to me, as the court is aware, and we are working well together. But I do need to set this out. Well, actually, I think we can just schedule it for trial, and then also, Your Honor, my client has asked me for two things this morning. One, that I make his wishes known, his request known, that he is requesting that the court set aside the contempt that he was previously sentenced on January 24th. Two, that he would like an opportunity to speak with the court, and he understands that he needs to do that within boundaries and guidelines, and be respectful in speaking with the court and take turns. And so I told him that I would ask the court to give him an opportunity to speak to the court, and he has assured me that if at any time I instruct him that he needs to stop conversating, that he will follow my lead, Your Honor.
All right, let me first ask Ms. McClure, is there anything we need to address from people's side at this point?
Just that I wanted to place the offer on the record because I know Ms. Hennigan just inherited the case and we weren't really successful in doing that before. So at this time, the offer as stands is an attempt possession of meth and an R&O. We would agree to no habituals and no MDOC if he pleads to those counts.
Thank you,
As it stands right now, as current, he is a habitual fourth, and his guidelines are 46 to 120 in the MDOC.
Thank you, Ms. McClure.
Okay, and so if we get to a trial, how many days do we need for that?
Probably just one.
I was gonna say two, Ms. McClure, just a caution, but it's up to you.
Maybe a Wednesday plus another day, like a day and a half.
Yes, that sounds great.
All right, so I'm going to set it for a trial then, just so we have a date to move forward one way or the other. Ms. Clark, can you give us a 2-day jury trial date, please?
June 20th at 9 a.m. and June 21st at 9 a.m.
I'm available both of those days.
Mr. Sneed appears to be available then too. Yeah.
Okay, so let's set a pretrial then for June 12th. At 8:15. Obviously, if there's some resolution that gets reached in the meantime and you want to get into court before that, we'll do what we can to accommodate you.
Thank you, Your Honor.
Okay, so then, Mr. Lester, what is it that you would like to say?
Every time I try to say something, I was getting cut off, and not to be disrespectful, but it seemed like my Constitution and my civil rights are just being ran through. And it seemed like when I was trying to intervene to try to catch myself to make sure that I was being heard, it seemed like if I didn't say something at that time, I wasn't going to be heard. That's just any conversation between two men. That's usually how it goes. No disrespect to your cloth, your jurist, or anything to that nature, but I just wanted to make sure that I was being heard for the court of record, because it seemed like anytime I went to say anything else, I was being cut off. It started all the way down from Mr. Morgan, and I still feel like that my back is against the wall over some driving tickets. I've addressed those so many times that's what I was arrested for, and it's just like I'm not being heard. I'm not being heard, and I'm looking to you for some type of guidance, but then it seems like I'm being like double teamed from you and the prosecutor's office. I'm being held for something that I did over 30 years ago, 20 years ago. I haven't been in any trouble. I don't like being in this. I don't like it at all. I can't stand it. I'm around kids now. I can't stand how they look at this. I hate every bit of it. And I just got assaulted yesterday by 3 of them. And make it so bad, they put us all back in the same block, and I got assaulted in the hole. I don't get this. I have no patience for this anymore. And as far as the habitual go, well, you already know that, as far as that goes, the language from Michigan and Ohio is totally different. Totally different. And I always thought that had to be a pattern, and I don't have a pattern. This was something that happened in 91. The last time I got in any kind of trouble was in 2000. That's over 23 years ago. And under Michigan's rules, I just read it just not too long ago, that they had an automatic expungement after 10 years. So I'm still trying to figure out why I'm being hit with these habituals like I'm some type of, I stay in trouble all the time. I've done more in this community than anybody has ever been, that I've ever done anywhere else. I'm helping at shelters. I'm doing what I can. I helped at the women's shelters. It's not like I'm just sitting around and thumbing around getting in trouble. I'm not like that. I don't like trouble. I've been trying to help people. I'm not Jesus or anybody trying to save anybody, but I'm trying to be mindful of my fellow human being. That's all I'm trying to do. But I'm tired, man. I've lost everything in the past 6 months. It feels good to say that I'm a government contractor after coming where I come from, because I'm not from here. And I was being told by Ohio that I need to come take care of this. But I didn't want to come in that courtroom without me having some type of foundation to establish myself. I wasn't trying to duck these tickets. And that's what they're trying to make it seem like. And they're trying to make it seem like I was getting in trouble on top of it. And I wasn't. I was assaulted by 2 of the police officers. My finger was busted wide back open. I was stabbed. And that officer knew prior to that. This was what they all ensuing. And nobody seems like they even care. I've been asking for the August 2nd body cams, and I'm not getting anywhere so you can see it for yourself.
Okay.
I am not a troublemaker.
Mr. Fain, wrap it up for me, okay? So that the judge can move on and I can make
That part up. I'm just hurt by
you.
Feelings, man. It hurts me as a human being to see somebody treat me like this. I don't treat people like this.
Okay. Thank you. Thank you, Your Honor, for giving him an opportunity to speak to the court. I'm looking into these things that Mr. Fain is concerned about, and I will be going back over to meet with him to discuss it further. I just wanted him to have a chance today to establish a little trust in the court that you will hear him when he works within the boundaries and the court rules that are established.
All right, I have previously stated in other court hearings my reasons and rationales for the decisions that I've made in this case, and I would stand on those. So we can conclude the pre-trial in this matter. Mr. Lester, you can let the officer that's with you know that you are done with court for today.
I'm going to do a breakout session before I go with Mrs. Hennigan before I go. I need to talk to her real fast. Because I'm still, I ain't got no
Your Honor,
choice.
is the court able to accommodate that? If not, I can go over and see him.
Yeah, I can't do that briefly.
Thank you.
I didn't hear what he said. I could barely hear
He's
you.
gonna do the breakout. Hang on, hon. He's gonna do the breakout. Just hold tight. He's gonna put us in a room together.
Do this.
Okay, let's see, Mr. Dagger Margosian, are you ready to proceed?
Yes, if the court has received an amended information.
Your Honor, I don't know that the court's received, I see it's been created in our file. I don't know that she's finished it yet though, so she should be sending that over momentarily.
Okay. All right, so we'll wait just a minute till we have that. Ms. Underwood, who are you ready to proceed with?
I'm ready to proceed with Mr. Rakes, Your Honor.
All right, we are on the record in file 21-20656-FH and 23-21455- I'm sorry, 21-20570-FH and 21-20656-FH, People versus Devin Dean Rakes. We're here today for probation violations in both of those cases. We are proceeding today partially, in person with respect to Ms. Underwood and Mr. Rakes. So Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Mr. Rakes this morning, Your Honor. Thank you.
And where do we stand with Mr. Rakes?
Your Honor, I talked to the prosecutor. There are no charges yet, but I still anticipate them as part of this violation. So I would ask, Mr. Rakes is here this morning. He appropriately, as he is out on bond, I would ask the court to put this over for maybe 2 weeks, Your Honor, giving us time to establish firmly whether or not there are going to be charges filed in this alleged assault.
I apologize. Did you say 2 weeks?
Yes.
So that would be the 21st. So we'll set it for February 21st at 8:15 a.m.
Thank you, Your Honor.
Okay, Mr. Rakes, if you want to wait here, we'll get you a notice for that hearing before you leave.
Okay, Mr. Rakes, you can appear by Zoom for that if you'd like.
Okay.
Okay.
Thank you.
Have a seat. Your Honor, do you by any chance have Mr. Smeed in your?
Yes.
Because I believe Mr. Owutukoper is here on that. And we could
Yep,
probably get that
I
done.
do have Mr. Smeed. I also have Tremaine Jones.
Oh, you don't have Mr. Smeed?
I do have Mr. Smeed. I also
Okay.
have Mr. Jones.
Okay.
All right, Mr. Smeed, can you hear me? Mr. Smeed's audio is not connected right now. Okay, Mr. Smeed, are you able to hear us now?
Yes, I can.
Okay. This is file 23-21455-FH and 23-2146456-FH. People versus Matthew Edward Smead. We are here today for a pretrial hearing in both of these cases. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Owutu-Coker.
Excuse me. Good morning, Assistant Attorney General Emmanuel Owutu-Coker, behalf of the people.
Ron Dundewitt on behalf of Mr. Smead, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Smead's
Your Honor,
cases today?
there is income withholding on these files. Mr. Smead is making payments. However, it is not enough to satisfy his requirements. So we would like, Your Honor, I believe the prosecutor would have no objection to a 60-day adjournment. However, Mr. Smead is going to have to buckle down on the payments, Your Honor, and make sure that his child support is appropriate. I don't know when he's last been to the front of the court, but he does need to make his monthly obligation, Your Honor. But we would ask for a 60-day adjournment in this matter.
Mr. Owutu-Coker, anything to address from the people's side?
No, everything stated by Ms. Underwood is correct, and people have no objection.
All right, let's go with April 10th at 8:15.
And I will be happy to do the stip to adjourn with permission from Mr. Owutu-Coker in this matter, Your Honor.
Yes, you have my permission. Thank you.
All right, so Mr. Smead, the next date that you'll need to log in is April 10th at 8:15 a.m. I would note that we are at 189 days since bindover on this case, and so if we're still not meeting the monthly obligation of child support, then the court's going to have to move forward and set it for a trial at the next pretrial.
Thank you, Your Honor.
Mr. Smead is raising his hand. Do you want him to speak directly, or do you want to meet in a breakout session?
Mr. Smead, is this something we can discuss later?
It's just something real quick.
Okay, I'm sorry. What?
The last court hearing, when they sent in the income withholding form, friend of the court sent it to the wrong address. I contacted them. They got everything situated. And I just got my last W-2, so I'm getting ready to actually file 2 years worth of taxes because I forgot to file my taxes last year.
That should help a lot. Thank you, Mr. Smead.
All right, so you're all set, Mr. Smead. You can go ahead and log out.
All right, thank you.
And Ms. Underwood, are you ready to proceed with Mr. Jones?
I believe we can, Your Honor.
Mr. Jones, I'm going to need you to, there we go. Can you hear us, Mr. Jones?
Yes, I can.
All right, we are on the record in file 16-18070-FH, People versus Tremaine Jody Jones. We are here today for a pretrial conference in this case, and we are proceeding today partially by video conference, partially in person. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Owutu-Coker.
Good morning, Assistant Attorney General Emmanuel Owutu-Coker, on behalf of the people.
Ron Dundewitt on behalf of Mr. Jones, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Jones' case
Your Honor,
today?
I believe the pretrial would be on the bench warrant. this is a matter that Mr. Jones allegedly did not appear for sentencing on back in 2017, Your Honor. I would ask that the court set this matter post haste for a sentencing. And if the court needs to have a pre-sentence prepared in this matter, that they do so. And I think adjourning the bench warrant out to that point would be appropriate in this matter.
Okay, so this is a case that goes back to 2016. So even if there is a pre-sentence report, I'm sure that's going to need to be updated with the last 8 years of whatever has happened. So I will set this for sentencing on March 15th at 8:15 a.m.
Your Honor, I know Mr. Jones wishes to be heard as to the issue of the tether in this matter. Your Honor, Mr. Jones is currently on a tether, and it is creating great financial hardship. The AG's office expects Mr. Jones to pay child support and pay $70 a week, I believe it is, for a tether, Your Honor, and that is creating a major problem for Mr. Jones. We would ask if the court would consider regular check-ins with Mr. Coach rather than a tether in this matter, Your Honor. Thank you.
Your Honor, I also believe that Mr. Jones has a probable cause conference set for related absconding charge on March 15th. I'm not sure if that'll interfere with the sentencing date, but just so the court's aware of that. And then with respect to the tether, the people would just request that that remain in place, given that Mr. Jones was absent since 2016. So I think it is appropriate to keep that.
Your Honor, I've been on the tether for 4 months, Your Honor. Over 4 months. I could have paid all that money towards my child support. And I did show up to court. My last court date, I showed up in person.
All right, so Mr. Jones, I acknowledge he's been on tether for 4 months, but he failed to appear at a sentencing in 2017 and was not seen again until November of 2023. Sir, I'm not going to change my decision. I think the tether is in place. And I think it's necessary under the circumstances so that we can keep track of Mr. Jones' location and to ensure that he will appear at the sentencing hearing this time.
Okay, Your Honor, I might just turn myself in.
I have decided, and I'm not going to have any further discussion or debate about the issue. That is the decision.
No, actually, can I turn myself in, Your Honor? Because I can't afford it.
Well, if you stop paying, then I'm going to revoke bond and then you can turn yourself in.
Okay, Your Honor.
We're gonna need some kind of address or way to contact him. Or he needs to report to our office.
All right,
Either way.
I'm going to place Mr. Jones and Ms. Holly in a breakout session so that Mr. Jones, you can give her your contact information.
Okay.
Okay, Ms. We do have Mr. Folds here from MDOC.
Mr. Foltz,
Yes.
I'm ready.
Okay, Mr. Folds,
Yes, sir.
we are ready to begin your hearing now. So we are on the record in file 23-21481-FH. People versus Joshua Dwayne Folds. We are here today for a pretrial hearing in this case. We are proceeding today by video conference and also in person. First, let me ask the attorneys to place their appearances on the record. We have a prosecutor on this case.
Phoebe McClure on behalf of the people.
Rhonda Underwood on behalf of Mr. Foltz, Your Honor.
Okay, and where do we stand with Mr. Folds' case today, Ms. Underwood?
Well, Your Honor, I spoke with my office spoke with the Forensic Center, and I've spoken with Mr. Foltz. Mr. Foltz has finally seen the doctor as to his criminal responsibility. The doctor is out until the 9th, but we anticipate a report after that. What we would ask, Your Honor, is a perhaps 30-day adjournment to get that report. And as I've told Mr. Foltz, we will discuss the results of that report with him and proceed appropriately, Your Honor, in this matter.
Okay, Ms. McClure, is there anything that needs to be addressed from the people's side?
I don't believe so, Your Honor.
Okay, so we will, I'm sorry, did you say 30 days?
I believe that would be good, Your Honor.
Set this out to March 6th at 8:15 a.m.
And I will do the stipend adjournment with Ms. Mears' permission.
No objection.
Okay, and so, yeah, if you'll do that stipend order for the adjournment, and then Ms. McClure, if you could arrange for the writ, please.
We can do that.
Okay, anything else we need to address with this case today?
Nothing else, Your Honor. I would thank the MDOC and Kinchlow for their cooperation in an actual telephone conference with Mr. Foltz. It was very helpful.
Okay. Thank you then, Mr. Foltz. You can let the officer that's with you know that you are done with court.
I wanted to ask my lawyer if I could speak with her for a quick second, if it was possible.
I'm sorry, Mr. Foltz.
He's asked to speak with you. Do you want to get on a device and?
I can get on my device.
Okay.
Okay.
All right, Mr. Foltz, she's gonna go.
Mr. Foltz, can we do this at another time? Because I'm really backed up.
It's sure, you know when it'll possibly be, Ms. Underwood? You give any time you think that it's possible, any time you think is as soon as possible.
Sorry, you're vibrating up. I'm sorry.
I said, you know, when you think you'll be able to schedule me, ma'am?
I can't.
He's asking when you think you'll be able to speak to him.
Well, probably early next week. Would that be good?
She said early next week?
Yep.
Okay, that's fine. Thank you.
Okay, thank you, Mr. Foltz.
All right, thank you all. Have a blessed day.
You too. I'm gonna go back next door for a few minutes.
Can we call Jessica Lukes real quick? She's not here.
Who?
Jessica Lukes.
Oh, okay.
You're on the record in file 23-21634-FH and 23-21635-FH, Jessica, or People versus Jessica Lynn Lukes. We are here today for a pretrial conference in both of these cases. We are proceeding today by video conference and in person. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
BB McClure on behalf of the people.
Rhonda Underwood on behalf of Ms. Lukes, Your Honor.
All right, and Ms. Lukes is not logged into the Zoom session today, and she is not present here in the courtroom. Ms. Underwood, do you have any thing you'd like to say about?
I have no knowledge as to her whereabouts. I did try to call her a few days ago and was not able to get a hold of her.
All right. Ms. McClure, anything to address from the people's side?
No, nothing.
Okay, so Ms. Lukes has not appeared here for her pretrial this morning. I do not see any prior failures to appear in the files, so I am going to give her the 48-hour grace period. If we haven't heard from Ms. Lukes within 48 hours, I will revoke and forfeit her bond and issue bench warrants in both files with bond on the bench warrant to be $25,000 cash or surety in each file.
Thank you, Your Honor.
Thank you. First. Okay, Mr. Murphy, I have Mr. Stewart here. Do you need a breakout session with him?
I don't think so, Your Honor, unless he wants to talk to me.
Mr. Stewart, do you want to speak to your attorney before we start your hearing? You are muted, sir. You're going to need to unmute your device.
There we go. Can you hear me now?
I can hear you now, yes.
Okay. I do not need to talk to my attorney.
Okay. We're on the record then in file 23-21657-FH People versus Zachary Allen Stewart. We are here today for a pretrial conference, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
BB McClure on behalf of the people.
Matthew Murphy appearing on behalf of Mr. Stewart.
And Mr. Murphy, where do we stand with Mr. Stewart's case today?
Your Honor, I was going to ask if we could set a jury trial on this matter. I think the case will be resolved short of actual trial, but I know the case has been bound over for a bit of time now, not super long. But I would ask for just a one-day jury trial to have an end date put on the matter, and then a final pretrial. And I'm going to discuss the matter further with Mr. McClure in between now and then. And I think we'll probably come to a resolution, though, at the final pretrial.
Okay, Ms. McClure, anything we need to address from the people's side other than setting a trial date?
Just that, according to my records, this is our first pretrial. I think instead of taking up a trial date, I'd ask for another pretrial, but it's up to your court's discretion.
Again, we'll be fine with that, Your Honor. Leave it in the court's discretion as to how to proceed with that matter.
Okay, so it was bound over back in December. It does look from the file like this is the first pretrial, so I'm okay with another one. We could go with March 13th at 8:15.
Yes, Your Honor.
Okay, so March 13th at 8:15 is the next time you'll need to log in, Mr. Stewart. Mr. Murphy, would you be willing to prepare a stipulation and order for that adjournment?
Yes, Your Honor.
All right, then, Mr. Stewart, you can go ahead and log out.
All right. Thank you, sir. Thank you, Mr. Stewart. I'll give you a call. Okay. Okay. Sounds good. Thank you. Thank you, Your Honor.
Okay, and let's see, we had, I think, a waiver for Mr. Underwood, so I think that's everything for you, Mr. Murphy.
I do believe so, Your Honor. Yes, I wanted to make sure Mr. Underwood didn't accidentally, he isn't trying to zoom in or anything, is he?
No, I have not seen him.
All right, thank you, Your Honor. Everyone have a good day.
Okay. Mr. Mr. Goldstein, I have not seen Mr. Crone.
Your Honor, I can try to call him. I'm sort of juggling two hearings this morning. I can try to call him. He was there last week at the prelim in his other case. And given the fact that he's heavily medicated, my guess is it's just confusion. So all I was going to do is ask to adjourn this case over. The other case just got bound over. We need to get both of them on at the same day at the same time. If Ms. McClure would prefer that I try to get a hold of him, or the court does, I'll be happy to do that.
Wait, give me just a second here. Okay, it looks like his arraignment is next Wednesday at 8:15. Ms. McClure, any issue with just setting this over to next week at 8:15?
As long as the court notes that he did not appear today and takes that into consideration if he doesn't appear next week.
Your Honor, we have already filed a waiver for next week because I'm going to be out of the country. We were going to ask that both matters set for pretrial on the 20th of March.
That's fine, Judge, if we want to set it for then and hope he shows up then.
And I will make sure if I have to put him in the trunk of my car, I will make sure that he is there on that date. Ms. McClure knows he was there last week for the exam, Your Honor.
That's correct.
All right, so I'm not here on March 20th, so we'll set everything for whatever date we get worked out for the first pretrial in the 24 case.
I'll work that out with your secretary, Your Honor. Thank you.
Okay, all right. Okay, Mr. Dagger Margosian, you also had Cody Felton, who is not here. Do you know anything about him?
Yeah, I tried to make contact with Mr. Felton earlier this week. I wasn't able to. He has shown up. Well, I'll let the court call it. Okay.
Okay, thank you. We're on the record in file 23-21654-FH, People versus Cody James Felton. We are here today for a pretrial conference in this case. We're proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Connor Michael Dagger Margosian for Mr. Felton.
All right, and the record should reflect this was set for 8:15 this morning. It's now 10:05. Mr. Felton has not logged into the Zoom session and is not present here in the courtroom. Mr. Dagger Margosian, is there anything you'd like to say with respect to Mr. Felton?
Your Honor, Mr. Felton lives on the west side of the state. While this case was in district court, he had appeared at the hearings. We did waive the matter. Mr. Sneed and I did agree on a resolution. So I guess what I would ask the court to do is, if the court is going to to issue a bench warrant, first off, I would ask for the 48-hour grace period, but also part of the plea deal, really all of the plea deal, involved that Mr. Felton pay an amount of $951. And so I would just ask that that be the bond amount. And then that would really resolve the case anyway. So that's my request at this time.
I'm sorry, what was that amount?
$951.
All right, Ms. McClure, anything you want to address from the people's side?
Judge, I think this is the first pretrial after the arraignment was waived, so he hasn't appeared yet in circuit court. So I have no objection to maybe just putting this out for pretrial and sending him a letter or something like that, if Public Defender's Office does that, and then addressing whether he fails to appear at the next pretrial. But it also makes sense to make his bond what he owes. So I guess I'll leave it in the discretion of the court.
Okay, what I'm gonna do is I'll set this out for 2 weeks to February 28th, which should be ample time to get in contact with Mr. Felton. And I will find he has failed to appear here today. So if he doesn't appear at the next one, he would not then be entitled to any kind of grace period, and I would likely proceed with a warrant at that time. So Mr. Dagger Mangosian, could I ask you to do a stipulation in order for that adjournment to the 28th?
Yes. Yeah.
Okay. And so I think the only one I have left is Mr. Ryan.
Judge, did you already do Kevin Berlindy?
Oh, no, we have Mr. Berlindy also, sorry.
Okay, no, that's okay. Make sure my list is correct.
And I think we're still waiting for the amended information from Mr. Bryan.
Is Mr. Bayonetto in the courtroom still?
He is not.
Okay.
Just try to.
Apparently we had an email, but didn't have the attachment, so we'll try to get that sorted out.
And then who do we have on Mr. Berlindy?
That'll be Ms. Underwood when she gets back here.
Okay.
Okay, I do now have an amended information in the file ending 165 for Mr. Brian. Oh, I'm sorry, hang on.
It's already got four.
Oh, okay, so there had been previously an amended information file that had count 4 attempted resisting and obstructing. Is that what we need, or do we need something else?
Your Honor, is Mr. Bayonetto present?
No, he's in Judge Anselon's court right now.
Okay. The reason why I ask is him and I have worked out a plea deal. We had been going, is this case called, did we call this case?
No, I just need to know if I have the correct amended information.
I understand. I'm wondering that as well.
All right. Well, if you need to talk to him further about it, we can wait. I just thought.
I don't need to talk with him further. It's just, I just want him to confirm what is on the amended information, I guess is all. So we will need him present.
Okay, we can wait till he gets back then.
All right. Your Honor, I have a few cases in Judge Anselon's court. Is it okay if I pop over there and then once Mr. Bayonetto comes to this court, I'll return?
Yep, that's fine.
All right, thank you.
Apologize, Your Honor, I stepped next door.
Yeah, no problem. Mr. Dagger Margosian just went over there, so.
Court should have the amended now, right?
Yeah, so the amended information I have. I guess Mr. Dagger Margosian wanted to talk to you about it, so I guess we just wait for him to get.
Send a message as well. Before we go back on, the information that we had was 2 counts in the 22 case for Mr. Bryan was 2 counts of R&O, 1 count of domestic violence. So we added a 4th count of attempted R&O on the amended, and then he'll be pleading to that and an aggravated DV in the 23 case. Okay.
So we had actually had an amended information filed back in January that had an added count for attempted RNO.
Right, so he'd be entering a plea to that attempted count 4.
Okay. So we've prepared a new amended information.
It was the same amended, I signed it today. The one that we had that one came over to you, we didn't have as signed.
I've got a signed and filed amended information filed on January 5th. That appears to me identical to this new amended information.
So then we can go forward with that then, Your Honor. I
Okay.
apologize for the confusion.
All right, so it's the attempted RNO in the 22 case, and then I'm sorry, what was it in the 23 case?
Would be the aggravated DV, which I believe is count 4.
Okay, we are on the record in file 22-21165-FH and 23-21307-FH, People versus Kyle Dennis Bryan. We are here today for a pretrial conference in both of those cases, and we are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayonetto?
Alex Bayonetto for the People.
Your Honor, Michael Dagger Margosian for Mr. Bryan.
All right, and sir, you are Kyle Dennis Bryan? You are muted.
Yes, sir.
Okay. So my understanding is there's a plea agreement that's been reached. So Mr. Dagger Margosian, you want to state the terms as you understand them, and I'll ask Mr. Bayonetto to confirm.
Your Honor, my understanding of the plea deal is that Mr. Bryan will be pleading guilty to one count of attempted RNO on the 22 file and one count of ag DV on the 23 file, with a sentencing agreement for no more upfront jail. And in exchange for that, the remainder of the charges on both files will be dismissed.
Okay, Mr. Bayonetto, is that a complete and accurate statement of the agreement?
It is, Your Honor, yes.
All right, Mr. Bryan, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Kyle Dennis Bryan?
Yes, sir.
Mr. Bryan, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 22-21165-FH to count 4 on the amended information, attempted assaulting, resisting, obstructing a police officer?
Yes, sir.
You understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $1,000 fine?
Yes, sir.
Is it also your intention to plead guilty in file 23-21307-FH to count 4 aggravated domestic violence?
Yes, sir.
And do you understand that the maximum possible penalty for that offense is also 1 year in jail or up to a $1,000 fine?
Yes, sir.
Are you satisfied with Mr. Dagger Margosian and the advice he's given you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than what's been discussed on the record this morning. Is that correct, Mr. Bayonetto?
That's correct.
Mr. Dagger Margosian?
Correct, Your Honor.
Is that also your understanding, Mr. Bryan?
Yes, sir.
If a guilty plea is accepted, there will be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have me order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify if you wanted to testify. Do you understand, Mr. Bryan, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any conviction from the any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about November 3, 2022 in Clinton Township, Lenawee County, Michigan, that you did commit the offense of attempted assaulting, resisting, obstructing a police officer?
Guilty.
And how do you wish to plead to the charge that on or about February 27, 2023 in Clinton Township, Lenawee County, Michigan, that you did commit the offense of aggravated domestic violence?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the pleas?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Bryan to plead guilty?
No, Your Honor.
No.
Mr. Bryan, other than as we've talked about on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes, sir.
All right, Mr. Dagger Margosian, would you like to establish the factual basis?
That's fine, Your Honor. Mr. Bryan, on November 3rd of 2022, were you in Clinton Township in the county of Lenawee, state of Michigan?
Yes, sir.
And on that day, did you encounter a law enforcement officer?
Yes, sir.
And was that law enforcement officer giving you directives and or orders?
Yeah.
And did you attempt to resist those lawful orders?
Yeah.
Okay. And it was a MSP trooper, Michigan State Police trooper.
Yeah.
Okay. I think I'm satisfied with that, Judge.
Mr. Bennett, are people satisfied?
The only thing I would add, Mr. Bryan, you knew that that was a Michigan State police officer, didn't you?
Yeah.
I'm satisfied, Your Honor.
It's fine.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Bennett?
As to the R&O charge, I believe it has, Your Honor.
All right. Yeah, I'm sorry, Mr. Dagger Margosian, do you want to proceed with the domestic violence charge?
Yes, I'm satisfied with the 2022 case. Mr. Bryan, as far as the other case on February 27th of 2023, again, were you in the Clinton Township, County, Lenawee, state of Michigan?
Yeah.
All right. And was there an altercation with an individual, Timothy Bryan?
Yeah.
And Timothy Bryan is your father?
Yes.
Okay. And you, at that time, were you living at the same address as him?
Yeah.
Okay. And did you assault him in some way?
Yeah.
Okay,
Yeah,
what
it
did,
is.
what did you do?
We punched each other. I punched him.
Okay, and that was obviously without his consent?
Yeah.
Okay. And did that cause injury to him?
No.
Okay. Did he have to, did he have to receive any medical treatment?
No.
Okay. All right, Your Honor, I'm satisfied as to it establishing a domestic violence assault. If Mr. Bayonetta wants to volunteer, he certainly can.
Now, Mr. Bryan, would you have any reason to dispute that your dad did have to have the injuries he sustained during the assault checked out by a medical professional?
Say that again. Sorry.
Are you disputing that your dad had to have those injuries looked at by a medical professional?
No. Sorry.
Your Honor, I think that would satisfy the aggravated DV.
Has the court complied with MCR 6.302 B, C, and D then, Mr. Bayonetta?
I believe it has, Your Honor.
Mr. Daggerman goes.
Yes, Your Honor.
All right, I will accept those pleas. They've been given understandably, voluntarily, and accurately. Mr. Bryan has had full knowledge of his rights. He's had competent counsel. I will refer this matter to the probation department, or I'm sorry, the court's made no agreement regarding the possibility of possible sentence, plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed it on the record here this morning. So I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for March 15th at 8:15 a.m. Mr. Bryan, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Okay.
And I am going to place you in a breakout room with Ms. Holly from the probation department so that she can collect your contact information.
Are these misdemeanors?
Oh, yes. You know what? I'm sorry, they are. So, Mr. Bryan, what you'll need to do in terms of the pre-sentence investigation then is report to Mike McCarron in district court probation this coming Tuesday. So that is Tuesday, February 13th. You need to report in person to district court probation at 8 a.m. Okay.
All right.
Thank you.
All right. You are all set then, Mr. Bryan. You can go ahead and log out.
Thank you.
Thank you, Your Honor.
Thank you. Should be up to.
Thank you. I think I'm all set here.
Okay, thank you, Mr. Dagger-Magosian. I just sent an email.
Are we ready on Berlindi now or waiting on him?
We're just waiting for the jail to bring him to us.
Oh, okay. Sorry, I had stepped away. Rhonda, because this is Amanda's case and I don't have any file or any notes on it, do you need anything from us on that?
I don't think so. The offer is as charged, I believe, and he also has a VOP.
So you don't think you need anything?
Not at the moment, Phoebe.
Okay. Do you know what you're doing with him today?
I need to talk to him.
Oh, okay.
Yeah.
Right, we're on the record in file 23-21604-FH and 23-21206-FH. People versus Kevin Ryan Berlindi. We are here today for arraignment on a bench warrant for probation violation. We are proceeding today by video conference. Sir, you are Kevin Ryan Berlindi?
Yes, sir.
Mr. Berlindi, have you received a copy of the warrant for probation violation?
Yes, Your Honor.
The warrant for probation violation alleges that you violated the terms of your probation by having non-consensual sex with a female on January 28th of 2024. You had previously
and try to find out because the person that you probably spoke with is not here.
in the 23-21206 file pled guilty to failure to comply with reporting with a second habitual offender notice.
Oh, tell him.
So maximum possible penalty for that, 3.5 years in prison or up to $2,000 in fines. Mr. Verlin, is there a way you can shut the door or something to block out the noise that's going on at the jail?
What's up? No, he wants us to shut this door.
Oh. All right, so were you able to hear all that, Mr. Verlindi?
Not really, Your Honor.
All right. You had previously pled guilty in the 23-21206-FH file to failing to comply with reporting duties with a second habitual offender notice. So the maximum possible penalty for you in that case would be up to 3 years in prison and or a $3,000 fine. Do you understand that?
Yes. Not really. I was told, Your Honor, that there was going to be no stipulations and there was no habitual was going to be there.
All right, so that I'm just advising you of what you pled to and what the maximum possible penalty for that offense is. You do have the right to be represented by an attorney here today and at any other proceedings that we have in this matter. If you can't afford an attorney, I'll appoint one for you at public expense. Do you understand that?
Yes.
Do you want to be represented by an attorney?
Yes.
Do you have the ability to pay for your own attorney?
No, sir.
All right. I will appoint the public defender's office to represent you with respect to the alleged probation violation and place you in a breakout session with Ms. Underwood. If you'll give me just a moment.
Hey, Judge.
Yep.
I'm just guessing. I show on my PSI that the 21206 was just a sex offender failure to comply with reporting and duties, which was a 2-year. Are you looking at he has a new felony charge that you have as well? I was just wondering if maybe it got mixed up. But I'm just showing a 2-year max on this one that I have him on currently.
Oh, I'm sorry, I misread the plea form. All right.
He does have another felony that I think that you have again today for the similar charges, but I don't know what they worked out with that. But I think the one that I have him on, I just have a 2-year.
Okay, yeah, you are right. I will get that corrected when they get back.
Okay.
Okay, we have Ms. Underwood and Mr. Verlindi back from the breakout session now. Mr. Verlindi, I apologize. I was incorrect when I told you about the habitual offender issue. There is no habitual offender in this case, so it is just the failing to comply with SORA duties. And so the maximum possible penalty is not the 3 years that I told you earlier. The maximum possible penalty in this case is up to 2 years in prison and or a $2,000 fine. So having said that, Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Verlinde on all the files we're dealing with today, Your Honor, and I think there are a couple.
Yeah, so we have the one we've discussed. The other file is 23-21604-FH, and that was set for pretrial this morning.
Your Honor, what I'm going to ask is that not guilty be continued on both files and that we have a pretrial next week.
Okay, and so Ms. McClure, you want to place your appearance on the new file or both or whatever you want to do.
Phoebe McClure on behalf of the people for file ending in 21604.
Okay. And so Ms. McClure, any issue with adjourning this to next week?
No objection.
So I will enter a not guilty plea on the probation violation 23-21206 file, and we'll set both of for pretrial a week from today, February 14th at 8:15 a.m.
And as to the second file that Ms. McClure is on, Your Honor, I will be happy to do the stip and adjournment with Ms. McClure's permission.
That's fine.
Okay. Thank you, Ms. Underwood.
Thank you.
All right. So Mr. Verlinde, you can let the officer that is with you know that you're done with court for today.
I believe that concludes my docket, Your Honor.
Yes, we are all set. Thank you very much, Ms. Underwood.
Thank you.